Parental responsibilities in Colorado are the right, or really the obligation, that's why it's called parental responsibility and not parental rights, to make decisions on behalf of the minor child. So these decisions are typically broken out into four main categories: decisions regarding the education of your child, decisions regarding the religious upbringing of your child, decisions regarding the extracurricular activities, the things that your child will do outside of school, and decisions regarding the health care about your child. These are responsibilities for both parents to contribute to the decisions in these four areas. And the rights that it affords a parent are the right to make decisions for their children. But really, we look at these as responsibilities to make these decisions in such a way that are in the best interests of the child. Whenever possible, these decisions should be made jointly, but sometimes the courts will give one parent an overriding veto over the other regarding one or more of these decision-making aspects. Parenting time in Colorado has to do with the child's right to spend time with each of his or her parents. And this is usually done in such a way as to make that time roughly equal or equitable. It is a presumption that the child should have maximum amount of time with each of the child's parents. It is not always possible that it is done equally because sometimes the parents live too far apart or their schedules are such that that is not possible, but it certainly is the predisposition. There are circumstances where the court would decide that it is not in the child's best interest to have an equal amount of time with both parents due to one parent or the other's inability or unwillingness to promote the best interest of the child during their time with them, and then the court might limit that time. But the parenting time is the child's right to spend time with both of the child's parents. People often ask about the difference between joint physical custody and primary physical custody. And in Colorado, those are not distinctions that we typically make. So joint physical custody, what other people might think of as joint physical custody, is something like the 50-50 schedule, whether that be week on, week off, or a 5-2-5 schedule, or a 3-4-3-4 schedule, or some other type of schedule that the parents put together that ends up being equal time. And then primary physical custody, what other states and what other people think about as primary physical custody, is one parent having a majority of the time. In Colorado, we talk about parenting time as a right of the child to spend the maximum amount of time with both of the child's parents. And that is only disturbed when the parent's schedules or distance or inability or unwillingness to promote a positive environment for the child interfere with the predisposition towards a more equal amount of time. Can parents share both legal and physical custody of a child in Colorado? Well, first of all, I think it's important to note that we don't really talk about custody in that way. So legal custody is something we refer to as parental rights, the right to make decisions for the child as to healthcare, as to education, as to religious upbringing, as to extracurricular activities. And that can be shared. In fact, it is preferable for that to be shared and for all those decisions to be made jointly and with conferral with the other parent. Similarly, instead of physical custody, we talk about parenting time, or the child's right to have the maximum amount of time that is in the child's best interest with both parents. And again, that also can be shared in Colorado. And so certainly when parents work well and co-parent well enough together that they can have an equal amount of time and make all the important decisions for the child's life jointly and in joint conferral one with the other, that is what other states would consider joint physical and legal custody. And certainly in Colorado, that is the preference. Custody for children of unmarried parents is decided in pretty much exactly the same way as for married parents. The parenting time, with the right of the child to spend a maximum amount of time with both parents, and the parenting responsibilities, in other words, the parent's responsibility to make decisions for the child, are decided upon using the primary standard of the best interests of the child. And it is considered in Colorado to be generally in the best interest of the child for both parents to participate both in the decision-making aspect and in the parenting time with the child. And the fact that they had never been married really does not come into play.